Hey, Judge Faris, let me see. Judge Faris, just let me know when you want to begin. I know that, I think we started a little bit after 9 last time.
Yeah. Well, we got Judge Collins in the waiting room. We should probably let him in first, I suppose.
But he's not going to be moderating, as I understand. It's just going to be you and Carol and Djang, right?
He's just watching, as far as I know. So no wise comments from Judge Collins.
Well, okay. There he is.
We got a few people left in the waiting room. Maybe we can wait just a minute or two and let them all in.
Okay.
Hey, Dan, how you doing?
Good. I'm going to sit back and enjoy the show.
Uh-oh.
Okay.
Okay, we got a couple. Well, let's see. There's still one left in the waiting room. Let's wait another minute or so. Okay, waiting room is empty. I think we should go ahead.
Okay, if you don't mind, Judge Faris, then let me just say a few words. Thank you all for participating in today's session and for your interest in bankruptcy. We put together this session and had asked some experts in the field of bankruptcy to join us and teach us here on Guam and the Northern Mariana Islands. We have attorneys both from Guam and the Northern Mariana Islands participating. And part of this was because of the shortage of debtor attorneys on both of our islands. And so today our panel of experts will be covering an overview of bankruptcy appeals. We have Judge Robert Faris, who's no stranger to Guam or the NMI. He is the Chief Bankruptcy Judge of the District of Hawaii, and he was appointed to the Bankruptcy Appellate Panel for the Ninth Circuit in 2015. And he has been a designated judge for our islands and some pretty serious big cases, the retirement fund cases, the Saipan and the Archdiocese case, both of which I've been assigned to, and it's been a pleasure working with him. We also have Ms. Caroline Djang, a former law clerk to 4 bankruptcy judges. She has vast experience representing both debtors and creditors. And so it's nice to have her here. She's also represented trustees and committees in bankruptcy cases and adversary proceedings. Among her many accomplishments is being named as one of the top 50 women attorneys and top 50 Orange County attorneys. So I hope that those of you who are truly continue to have this interest in bankruptcy will enjoy today's session on appeals, and Judge Faris will take it away. I know Judge Maglonia has joined us, and so is Judge Collins. We're all going to be participating by observing from the 2 best in appeals. Judge Faris.
Well, thank you very much. And thank you so much, Judge Djang, for setting this up and spearheading this whole program. Judge Manglonia, thank you for publicizing it. I want to thank Judge Collins of Arizona for being the person who sort of whipped the horses and kept us all in line and kept us all going. And thank you to all of you for participating. Our program today is about appeals in bankruptcy cases. And let me get my slides up here so you can see them. We're going to talk specifically about the rules applicable to appeals from Guam and the CNMI because they are different from the rules from bankruptcy court appeals in the States and in Puerto Rico, for that matter. I think it's important for people to know more about appeals. I believe a lot of attorneys get through a career without doing appeals, and appeals to many attorneys are kind of a scary thing. It's something you need to know because sometimes, I mean, you are all blessed with 2 excellent judges, but we're all human. I mean, you look at it this way, you could be in Hawaii and have some moron for a bankruptcy judge, but out there you got some really good judges, but we are all human. We do make mistakes, and appeals are the way judicial mistakes get corrected. So I think this is something that pretty much every lawyer should know how to do. Now, my presentation is going to have kind of a good news, bad news aspect for it. And let me start with my very first slide here. If I can change my slides. There we go. The first question is, what rules do you have to follow? And here I think there's good news, which actually is kind of bad news. The good news is that you only have to worry about the federal rules of appellate procedure. There are specialized rules in the rules of bankruptcy procedure for appeals, but those don't apply. Those only apply if you're appealing from a bankruptcy court to a district court or a bankruptcy appellate panel. In Guam and the CNMI, you have no bankruptcy court. So all your cases are in the district court. Therefore, all the appeals go straight to the Court of Appeals, and you only need to worry about the federal rules of appellate procedure. That's good news because it's simpler, but it's also bad news because the bankruptcy appellate rules were designed to cover some aspects of bankruptcy cases that are helpful to have in the rules. The federal rules of appellate procedure are kind of a one size fits all or one size fits nobody situation. So you may find little procedural glitches as you go through an appeal in Guam or the CNMI, and it may be helpful for you to take a look at the bankruptcy appellate rules to try and find a solution to propose to the court. So although you have the same basic set of rules, there are still some very important differences between appeals in bankruptcy cases and appeals in ordinary civil cases. The first big difference is identifying the order that can be appealed. You know, we know that you can only appeal from a final order, and I'm putting that in scare quotes because there's a big definition of finality. In a bankruptcy case in the district court, like all of your cases in Guam and the CNMI, the definition of finality is the same in bankruptcy cases as it would be in a civil case. In an ordinary civil case, the final order is basically the final order. It's the last order that decides all the claims and parties in the case once and for all. If you have a series of orders that dispose of pieces of a case, you know, for example, maybe part of the case is dismissed on a motion to dismiss, part of the case is disposed of through a motion for partial summary judgment, the rest gets resolved after trial, that final order that resolves the last set of claims is the final appealable order. Now, that doesn't work really well in bankruptcy cases because a bankruptcy case is actually oftentimes a series of disputes that have almost nothing to do with each other than the fact that the debtor or the debtor's property is involved in all of them. For example, let's suppose you have a bankruptcy case, and the debtor has some property, and the debtor also has a lawsuit going against somebody. The trustee might first of all decide he wants to sell the property, and there might be a dispute about that. Parties might argue about it. Then the court enters an order approving the sale. That order, if it's entered in a bankruptcy court, would be an appealable order because we have this, what they call the flexible finality standard in bankruptcy court. If that order were entered in the district court, it's not an appealable order because it's not the last order in the bankruptcy case. Let's suppose our hypothetical bankruptcy case goes on. The trustee looks into this lawsuit the debtor has against a third party and decides to settle it. The trustee can do that. He has to get bankruptcy court approval to do that. So the trustee files the appropriate motion. There are objections. People don't agree with the trustee's judgment about settling the case. And ultimately the court enters an order. In bankruptcy court, that would also be a final appealable order. In district court, it's not because it's not the very last order in the bankruptcy case. Now, this is a real problem because sometimes bankruptcy cases can go on a long, long, long time. The project I was working on here at my desk this morning was a set of findings and conclusions in a bankruptcy case that was filed in 2018. And even after I decide this dispute, there's more coming down. So that case will probably go on for 6 or 7 or 8 years before it's actually over. I had a case pending in my court. Actually, it ended before I was the judge, but this one guy had a personal Chapter 7 case. He was able to keep his personal Chapter 7 case going for 27 years. Now, those are rare, right? They don't usually go that long, but they do go on for a while. So going back to my hypothetical case, by the time the very last order in the bankruptcy case is entered, it could be months or years after the sale was approved. And that could cause real problems for the appeal. The appeal was more or less certain to be moot by the time the final order is entered. So what does that mean? Well, I think what it means is you're probably going to seek leave to file an interlocutory appeal in many circumstances in the district court bankruptcy cases in Guam and the CNMI, where you wouldn't have to seek interlocutory review if you were in a bankruptcy court. So there is this statute that allows you to seek review in the Court of Appeals from a non-final order. You have to start by going to the district court, the court you want to appeal from, and ask the district court to certify that, and the language of the statute is there has to be a controlling question of law. There has to be a substantial ground for difference of opinion about that controlling question of law, and there has to be a reason for an immediate appeal rather than waiting for later. And then once the district court gives that certification, you have to go to the Court of Appeals and ask them for permission too. So either one of the courts can turn you down. In ordinary cases, this is very difficult. It's really quite rare to see an interlocutory appeal motion get granted. And the reason is the appellate courts have plenty of work to do. They're generally not looking for more stuff to do. So in the typical civil case, you have to not only show that you meet the statutory standard, but you have to kind of catch the Court of Appeals' attention. You have to convince them that this would be something they would kind of enjoy or be interested in working on, and they wouldn't necessarily want to have to wait till the end of the case to work on it. So these are difficult. Now, I think in bankruptcy cases, if I were representing somebody in a bankruptcy case who wanted to do an appeal from the district court, I would say, look, the rules of finality in these district court bankruptcy cases don't work very well because we have to wait potentially years and years and years to file an appeal, and our appeal will almost certainly be moot by the time we're allowed to appeal as a matter of right. So you really ought to let us take an interlocutory appeal. And by the way, if we were in the bankruptcy court, we would be able to appeal this particular order as a matter of right. I think that might be a persuasive argument. I mean, I'm not on the Court of Appeals, so I can't give you any guarantees about that. But I think that if you point out the difference between the appealability standard in the district court and the appealability standard of the bankruptcy court, you might have a more persuasive argument for an interlocutory appeal. But the bottom line is, because of the way the bankruptcy system is structured in Guam and the CNMI, you may have to do more of these motions than you would have to do if you were in a bankruptcy court in the States. So there's also a difference in the due date. You know, the way you get an appeal started is by filing this thing called a notice of appeal. The due date for the notice of appeal in a district court case is the same in a bankruptcy case as opposed to any other civil case. It's 30 days. You got 30 days to file a notice of appeal. And there's also a possibility for seeking extensions under the rules that are quoted there or cited there on the slide. You should not worry about filing too soon. The rules are pretty clear that if you file before the order is final, that appeal is deemed taken from the final order once it's entered. So it's kind of like the rule that Mayor Daley of Chicago used to say. He used to say people should vote early and often. In appeals, you should probably appeal early and often, because if you're appealed too late or if you appeal from the wrong order, you're toast. So the good news here is if you weren't in Guam or the CNMI and you were in the bankruptcy court, you'd only have 14 days to file your notice of appeal. So you get an extra 2.5 weeks or so. Lucky you. Another place where bankruptcy appeals differ from other civil appeals is the rules of standing. You have to have standing in order to participate in a federal court case at any stage. You have to have a real concrete stake in the case before you can sue somebody or appear and be heard in the case. These rules apply to bankruptcy cases too, and they apply in kind of interesting ways. Basically, if the debtor doesn't like what the trustee is doing, the debtor is almost never going to have standing to appeal. And that's because, let's suppose, go back to my hypothetical case where the trustee wants to sell a piece of property. Unless there is a chance that there's going to be money left over for the debtor after all the creditors are paid in full, the debtor has no standing to complain about that sale because it doesn't affect the debtor's pocketbook. The debtor's not going to get less money or more money no matter what happens to that property. And almost always, bankruptcy cases are insolvent by definition. By definition, there's not enough money to pay the creditors in full. So it's very rare to see a case where a debtor has standing to appeal. The same would be true if you had a corporate debtor, a corporation in bankruptcy, and there was a proposed sale of the corporation's property. A shareholder is not going to have standing to appeal unless there's a good chance that there'll be money left over in the corporation after all the creditors are paid in full. So the rules of standing apply differently. Ordinarily, if you're a party to a case and you're on the wrong side of the judgment, you're going to be allowed to appeal that case. But that doesn't work out quite the same way in bankruptcy cases. There's another set of limitations on who can appeal, which aren't really about standing, but they're about preserving objections. In bankruptcy cases, we generally give notice to the world that, for example, the trustees filed a motion to sell a piece of property. And if you don't like that proposed sale, you must file an objection by a date certain. And if the objection is filed, we'll have a hearing on the objection on a certain date. But if nobody objects, we're going to cancel that hearing. And that happens very frequently in my court. I think you do the same in Guam, not so sure about the CNMI. We call it negative notice. If nobody files a timely objection, the hearing gets canceled, the motion is not heard. So people sometimes think, well, I won't file something. I don't write very well. It's kind of a lot of work. I'll just go to the hearing and orally raise my objections. That may be too late. There may be an order entered already on that motion by the time the hearing was scheduled. And if you haven't properly objected to the motion, you're not going to be allowed to prosecute an appeal. You've got to bring your concerns to the attention of the trial court before you can bring them to the attention of the appellate court. Also, any specific grounds of your objection have to be made. In other words, it's not just enough to say, I object, and then on appeal, spell out the 12 different ways in which you could have objected. You have to say all 12 of those reasons to the district court, or you won't be allowed to make new objections on appeal. I'm talking kind of fast here. Maybe Caroline feels like she can't get a word in edgewise, but please feel free to do so. Okay, the next step in an appeal is you have to designate the record. You have to point out which items in the trial court record you think are relevant to the appeal and that the Court of Appeals should look at. And my question is that important? And the answer is it absolutely is very, very, very important. The appellate court isn't required to look at anything you haven't told it to look at. So unless it's in your designation of record, the trial court is fully within its rights to say, well, we're not going to look at it. Now, as Judge Tydenko Gatewood mentioned, I sit on the bankruptcy appellate panel of the Ninth Circuit. We generally don't follow that rule. We will quite frequently look independently at the electronic docket and look at papers that were filed in the case, but we're not required to do that. So you shouldn't count on us doing that. And I don't think the Ninth Circuit is in that habit. I think they tend to look at what you give them, and that's all they're going to look at. So you have to think very carefully. Oh,
Sorry, I'll jump in here, Your Honor, when you're done speaking.
No, please go ahead.
So I like this slide, especially the heck yeah comment. I do have real world experience with this. And one thing I want to mention is the designation of record itself is just a list. So you can easily just pull that from the PACER docket. You don't want to overload on the designation of record, but if you miss something, then you're in a bind. And that's what happened to me recently. And for some reason, there was just one pleading that we didn't include in our designation record. We had everything else. We had the reply, we had the opposition, we didn't have the underlying motion. And for some reason, of course, Murphy's Law, that one pleading had exactly what we needed. There was a declaration, from the trustee that said exactly what we needed, and it wasn't in our designation of record. So we had to kind of 11th hour come up with a different way to bring in that fact. And it wasn't quite as good, of course. And we referred to a judge's tentative ruling, which we did put in the designation of record. So the designation of record can include, like I said, just PACER docket with the docket entry bracketed next to it kind of thing, but also transcripts. Oh, and there's the transcripts too that you have to order. The transcripts, things like tentative rulings, like I mentioned, all of those things. In my opinion, I think it's better to be over inclusive than just to pick certain things piecemeal. But and Judge Faris, I kind of suspected that the BAP did that they looked outside the DI, but not, you can't count on that. So definitely an important thing.
Right. I totally agree with the notion of being over-inclusive rather than under-inclusive. And you also mentioned the problem of transcripts, and that's really important. You know, we don't have transcripts unless somebody orders them and pays for them. We don't order transcripts ourselves. I'm sure the Court of Appeals doesn't do that either. So if you want to have a record for purposes of appeal of something that somebody said at a hearing, you got to get that transcript. Now, we in Hawaii, we put our recordings, the audio recordings of the hearings on the docket. And I can tell you that is one thing that we at the BAP will not look at. We are not going to sit and listen to recordings because that takes forever. You can read a transcript much, much, much faster than you can listen to a recording. So if something that was said at a hearing is important, if testimony offered was important, which it often is, then you just got to get that transcript. Transcripts are expensive, but there's just sort of no way around that, or those points will be gone for purposes of appeal. Okay, the next point, I think, Caroline, you were going to take this one. Am I right about that? Stays pending appeal? Please go ahead.
Thank you, Your Honor. And Judge Faris is kind of whipping through these slides. So I'm just going to spend a few seconds on my background. This is my 23rd year practicing bankruptcy. I hope I don't look that old, but I started my career clerking, as Your Honor said earlier, for the bankruptcy court here in LA. I clerked for 7 different judges over the course of 5 years. And during that time, I had the privilege of having one of my judges sit by designation for the bankruptcy appellate panel, which is what Judge Faris is on. And meaning a judge who's not normally on that panel gets to sit by designation and hear one of the appeals. And we heard that appeal in Phoenix, Arizona. And it was one of the best experiences of my clerking. It was the only all-nighter I ever pulled as a law clerk, because it was a lot of work. And I really, really admire Judge Faris and his brethren on the BAP, because it is a lot of work especially to go through the record. I thought that was just a ton of work, but it was very rewarding. The memo that I wrote ended up being not published, but used as the opinion of the bankruptcy appellate panel. So I was very, very proud of that. So I got to see it from the appellate court's point of view, as well as the litigant's point of view. In my practice, I've been on both sides, appellee side and appellant side. And I've argued several BAP appeals, bankruptcy appellate panel. Here in California, in the Central District, we have the choice of bankruptcy appellate panel or the district court. And I know I'm learning that in Guam, you do not have that choice. So I personally, and I'm not just saying this because Judge Faris is on here, like appeals before the BAP much more. I certainly prefer them because you have BAP judges, you have bankruptcy judges hearing your matter, and they speak the same language, they issue, etc. So I've had a couple of district court appeals, one of which went to oral argument, which apparently is pretty rare. And then the other one went just without oral argument, just on the papers. So I have a lot of experience. Recently, I've had 2 BAP appeals, and I argued the second one at the BAP. I tag teamed with another attorney. I think somebody might want to mute.
Yeah, let me see. Let me ask. Yeah. Oh, there you go. They just muted. Okay.
Okay, thank you. Okay, so the most recent bankruptcy appellate appeal, a panel that I did was actually before Judge Faris, and it was a really, really great experience. And I'm going to talk a little bit more about that later. So as to slide number 8, which is how can I get a stay pending appeal?
Actually,
the party must
Okay,
ask.
hold on, Ms. Chang. Let me see.
last time
Joe Krzyzewski, can you mute your phone there, Joe? Hello. Thank you. There you go.
Thank you. So the party must ask the district court for a stay before you would ask the appellate court, and that's FRAP 8A. A party filing a motion for relief from stay with the BAP district court or court of appeals would only be able to do that in the following situations. One, where moving first in the bankruptcy court is impractical. Two, where the bankruptcy court has not yet ruled. Or three, whether the bankruptcy court denied the request for stay. So I also have very recent experience filing a motion for stay pending appeal. And the movement must either provide adequate security in the form of an appeal bond or meet the standard for preliminary injunction, which is likelihood of success on appeal plus balance of hardships and tilts in favor of the movement. In my experience, we have to do both. I don't know if that's just something that's unique to the Central District, but the last time I moved for a stay pending appeal, the court also wanted to see evidence that we've gotten an appeal bond. And as it says on the slide, both options are hard, bonds are expensive. I went back and looked at the price that we paid for our appeal bond, and the deposit itself, I mean the premium that you pay in cash, is 0.3 to 4%. I saw my clients paid 1%. So they had a $1.1 million judgment against them. You also have to bond between 1.2 and 1.5 times the judgment amount. So they had a $1.1 million judgment against them. They had to bond in the amount of 1.6 million, and they had to pay in cash $16,000. So $1.6 million in collateral. So this is a lot, as you can tell. I mean, my clients happen to have the financial wherewithal to afford it, but I think mostly cannot. So that's a very difficult undertaking. And again, the preliminary injunction standard is very strict. It is, you got to look at 4 different factors: likelihood that the party seeking will prevail on the merits; 2, likelihood that the moving party will be irreparably harmed absent a stay; 3, the prospect that others will be harmed if the court grants a stay; and 4, the public interest in granting a stay. And the moving party doesn't need to satisfy all elements, but rather the court is to balance those factors. So next slide. So what could happen if I don't get a stay pending appeal? Well, the district court's order can be carried out. For example, an approved sale could close, a confirmed plan can be consummated, a money judgment can be enforced, all of the above. In fact, when I have clients who have a judgment in their favor, I say execute immediately, start attaching assets, start recording your judgment liens, etc. And also, secondly, the appeal could be rendered moot. So there are a few kinds of mootness that are listed here on the slide. One is constitutional mootness. And those of you remember from con law, this is just your typical, the issues presented are no longer live, or the parties lack a legally cognizable interest in the outcome. And an example that I remembered from law school, believe it or not, was a case called DeFunis versus Odegaard, a Supreme Court case from 1974. This is a plaintiff was a student who'd been denied admission to law school. He had then been provisionally admitted during the pendency of the case. Because he was slated to graduate within a few months at the time the decision was rendered, there was no action the law school could take to prevent that. The court determined that a decision on its part would have no effect on the student's right. Therefore, the appeal was dismissed as moot. So equitable mootness is you can't unscramble the egg. And this is a lot more common when you're talking about Chapter 11 plan confirmation. It basically means that even though effective relief could conceivably be fashioned, implementation of that relief would be inequitable. And typically in a reorganization, if a plan's been substantially consummated, assets have been sold, things like that, it is too hard to unscramble the egg. And that's equitable mootness. And the third type of mootness is statutory mootness. That's 363M, for instance, that provides that a purchaser of property of the estate is protected from the effects of a reversal or modification on appeal, as long as the purchaser acted in good faith and the appellant failed to obtain a stay of the sale. So when we have asset sales under 363, typically here in the Central District, we would either have a declaration from the purchaser or the court would take live testimony from the purchaser, basically saying this was an arm's length sale. There was no collusion. I had no connections with the trustee or the seller, and that's statutory mootness. So slide 10, next. We have tips for briefing and tips for oral argument. And I think that's Judge Faris, but I'm going to also provide my input from the litigant side, but I'll let Judge Faris take over on these.
Let me back up. Maybe I should be more clear about what the bankruptcy appellate panel is, so people will understand what we've been talking about, and also will understand some of the decisions you see when you do your research. So the statute says that every circuit has the option of creating a bankruptcy appellate panel. Doesn't have to, but it can. I think right now there's 5 circuits with BAPs. The other ones haven't for whatever reason. The 9th Circuit is the biggest circuit. We have the largest, busiest, kind of most institutional BAP. The statute then goes on to say that if there is a BAP in the circuit, then an appeal from a bankruptcy court order goes initially to the BAP. But if any party to that appeal objects, anybody, then the appeal gets rerouted to the district court. And I think the reason for that is, we are mere Article 1 non-life tenured judges, and inside the states, territories are different, of course, but inside the states, they want to give people easier access to a life tenured Article 3 district judge. So that's what the BAP is. We in the 9th Circuit, we end up hearing about half of all the appeals from bankruptcy cases. The other half end up in the district court. Our BAP in the 9th Circuit is staffed by 6 of us, 6 bankruptcy judges. When I started out, I've been on the BAP now for 8.5 years. When I started out, the estimate was it increased your workload by 30 to 40%. And in return for that, we get additional salary in the total amount of 0. So we get no extra pay for doing this extra work. But I do it because it's fun, it's rewarding, it's interesting. And besides, it makes me famous. I knew if I went to the Super Bowl, that camera would have been on me. They wouldn't have been looking at Taylor Swift. They wouldn't have been looking at the judge of the BAP for sure. I'm kidding about that. It's actually very rewarding work. I just enjoy doing it, and it's totally worth doing even for free. So that's what the BAP is. You don't need to worry about it because your appeals go straight to the Court of Appeals. So back to briefing. And I've done this both as a judge and as a practitioner, although as a practitioner was a long time ago, so I'm looking forward to Caroline's views on this. My first point is that the briefs are way, way more important than the oral argument. And if you take an appellate advocacy class in law school, most of it's going to be about the moot court, preparing for that oral argument, getting ready for that, because that's kind of the exciting part, right? You're on your feet, you're making your points, you're doing the whole Perry Mason thing. But in reality, the briefs are way, way more important than the oral argument. And the reason is we read the briefs very carefully. We have plenty of time to go over them. We study them. We have law clerks who help us work on them. The 3 of us on the BAP anyway, routinely meet before oral argument to have a preliminary discussion of the case. We don't decide the case till after oral argument. We've talked about it. So that is the best chance you have to kind of get ideas into the judge's head. By the time you get to oral argument, the judges have thought about the case, and they're kind of not totally set in their ways because cases do get turned around in oral argument, but you have a lot more influence over the judge's thinking in the briefs than in the oral argument. The other thing about the briefs is you can rewrite them. You can't redo an oral argument. I remember years ago seeing this cartoon, and it was this guy who was obviously a lawyer walking down the street. He had a hat kind of jammed onto his head and a coat pulled up, and he's holding a briefcase. And there's all these thought bubbles around his head, and every one of them said, "And then I should have said, and then I should have said." I mean, that's going to happen to you in oral argument. You don't get to redo any of that. But in your briefs, you can polish it up and get it all just the way you want it. So I would really encourage you to focus on those briefs. My next point is you have to plan ahead. You can't start thinking about your appeal after the adverse judgment is entered against your client. You have to be thinking about a possible appeal throughout your appellate, throughout your trial court work. I think actually it makes sense to, when you're preparing a case, you begin at the end and work your way forward. You don't start by drafting the complaint, for example. Ideally, you start by drafting the judgment you want the court to enter, and then you work back to the complaint you have to file to get that judgment. The same kind of thing is true for appeals. You need to think ahead. What's going to happen if I lose? How will I defend this thing on appeal? Have I made all the right objections? Have I offered all the evidence I have to make? if some of my evidence has been excluded, have I made an offer of proof to show what I would have shown if the objection weren't granted? So you always need to be thinking ahead to that ultimate potential loss. It's not fun to think about losing, but you really have to do it. The next point I make is that, one thing that actually took me by surprise when I became a bankruptcy judge and then a BAP judge is how important the standard of review at the appellate level and standards of proof and burdens of proof are at the trial court level. We at the BAP pay a lot of attention to the standard of review because it tells us how sure we have to be that there was a mistake. If it's a question of law, the rule is de novo review. That means we decide it ourselves. We don't really pay any attention, give no deference to what the trial judge did. If we think there's even the tiniest bit of error in what the trial judge did on a question of law, we fix it. On the other end of the spectrum is questions of fact. And there the standard of review is clear error. I found a case, I cite it all the time in my BAP decisions, it explains what the clear error standard means. It says that in order to be a clear error, an error has to be so obvious that it hits you with the impact of a 3-week-old unrefrigerated dead fish. That's how clear the error has to be for it to be clear error. And we pay a lot of attention to that. So when you're briefing, when you're arguing your appeal, remember, if you're talking about a question of fact, you've got a much higher hurdle to get over if you're the appellant. So you want to focus your appeal on questions of law. Then, of course, in between those two is the abuse of discretion standard, which is kind of a more flexible standard for situations where we want the trial judge to be more flexible. So I think most times when people write their briefs, they have a section on the standard of review, which is just boilerplate. They stick it in their briefs because the rules say it has to be there, and that's all they do with it. But you really need to pay a lot more attention to it as you're deciding how to argue your case. Accuracy. We actually read all this stuff. In the BAP, we have separate BAP law clerks. The Court of Appeals, of course, has, I think they each get 4 law clerks now. And these are some of the smartest young lawyers in the country. The judges themselves are some of the smartest judges of the country, and they read this stuff. They read every bit of it. They check your cases, they check your record sites. And if they're wrong, they're going to notice. Whether they call you on it or not, they're going to notice that it's wrong. So you got to just be be careful to be accurate about these things. My next point is kind of a general point about writing, and that is the best writing is not writing, the best writing is rewriting. I can tell a brief that somebody's basically dashed off and filed. I can also tell a brief where somebody's written it and then kind of started over. Rewriting is time consuming, it is difficult, it's painful, but it simply has to get done because your first draft isn't going to be good as your second or third or fifth draft. You just need to do it. The last point is kind of a plea, and that is almost every brief I've read is longer than it needs to be. You can always get a brief shorter, and lawyers have a lot to read. Judges have a lot to read. We probably have more to read than you do, I would guess. And we really are grateful when somebody kind of gets to the point, gets it done, and quits. That's a very nice. I like briefs that are that way. I don't appreciate briefs that are long simply because somebody didn't take the time to make it short. So think really hard about what you're saying. Decide whether you need to say the things you're saying. If you don't need to say it, take it out. Those are my points on briefing. So Caroline, you want to go ahead?
Sure. And of course, Judge Faris's pointers are much more practical and helpful than mine, but I think mine may be a little more relatable. So as to the first point, I cannot emphasize it enough because in 2022, I had a BAP appeal that was briefed and there was no oral argument. So this is one of the cases where the BAP decided that it was appropriate for a decision without oral argument. So in that case, you never had the opportunity to argue it in court. So you got to put everything into that brief. I actually enjoy writing a lot. I was an English major in college. And what do you do with an English major besides teach or go to law school? I went to law school. So I enjoy the process that Judge Faris was just talking about. And he's right. You got to start really early. The process of getting in all your sites is very tedious. Fortunately for me and for some people who work at larger firms, I do have a paralegal or a junior associate who can help with that, but not everybody has that luxury. So it is very time consuming, and you better have a site to every fact, because as Judge Faris says, they do read it. And I do believe it, and this is, like I said, I clerked for 7 years, that if you do see that an attorney has either misled you or cited to something incorrectly, that is a very, very poor reflection on both the attorney and their argument. And it definitely influences the way that the courts think. So you got to really, really make sure that you do that right. And the other one that I kind of wanted to speak to here was the last one, which is brief should be brief. And it's funny because I heard many times the old saying, I would have made this shorter, but I didn't have the time. And that quote has been attributed to everyone from Mark Twain to Benjamin Franklin to Blaise Pascal. So I don't know who said it, but I do think that that's absolutely true. If you have put the time in to make your brief more pithy and direct, I think it's just so much better for the judges to read. At least that was my experience on the clerk side of it. And I like writing shorter pleadings. I feel like when I see really long ones, these are not people who practice bankruptcy. That seems to be my experience. And just for more background, I've worked at full service firms my entire career. So I am frequently pulling work from other people's briefs and pleadings and being like, this is too long. And I think in bankruptcy, you can be simple, especially if it's the bankruptcy appellate panel as your judges. They know what you're talking about. You don't have to spend 2 pages on the standards of, basic bankruptcy concepts. So definitely and oh, by the way, one more thing I wanted to mention. An attorney that practices in LA here, he is in his 70s. He very late in his life decided he wanted to go be a BAP clerk. So he clerked for the bankruptcy appellate panel, and he actually wrote an article for the Daily Journal out here in LA about his tips for briefing, and that was number 1. It was be brief. He said if he gets one complaint the most from judges, it is that these briefs are too long. And there is indeed a character limit, so you can't go way overboard, like, file a 500-page motion, so or brief. So that would just be my input on this slide.
Yeah. One of my pet peeves is I'll sometimes see a brief that starts off by explaining how they've tried to be brief. Well, okay, you just wasted 5 seconds of my life right there. I'm not going to get back. Don't say that. It doesn't do anybody any good. All right, oral argument. Now, oral argument is important. It can be important. It's not as important as the briefs. And if you've written a really good brief, sometimes I see lawyers in the BAP. This is usually the appellee's lawyer, not the appellant's lawyer. But they're able to stand up and say, I've listened to the other side's oral argument. I think I've covered it all in my briefs. If the court has any questions, I'd be happy to answer them. And oftentimes we don't have any questions and that lawyer sits down. And I think that's a great day. If you find yourself in that position, you're in as good a position you possibly can be. So writing that good brief, that strong brief that covers all the issues carefully and accurately, your oral arguments can be very smooth. One risk of oral argument is you can actually talk yourself out of a victory by saying the wrong thing. So oftentimes, sitting down is the right choice. And if you've written a good brief, you have a better chance of being able to do that. My second point is, I remember being taught about job interviews. And when you go in for a job interview, they sometimes say, what you do, look at your resume and you think of your background and think of the questions that you really hope that interviewer doesn't ask you. That 2-year gap in your resume where you were in prison, for example. That's one really bad example. There's always going to be questions that you really don't want the appellate judges to ask because they're the hardest questions for your case. You have to approach those questions directly. You have to think up those questions and come up with the best answer you can possibly give to them and be ready for it. Now, in being ready for it, one thing you can't do is try to brush off the question, evade it, hide the weakness. we ask the questions for reasons. We ask questions to get answers. We ask questions about the weak spots because we know they're weak. And your not answering the question is certainly not going to help you. It's probably going to hurt you. So oftentimes the smartest thing to do is say, Your Honor, you're right. That is a weakness in my appeal. But here's the other points that make that weakness not important. So be prepared to concede if you have to. That's one lesson that they taught in the appellate advocacy class in law school that was totally wrong. I distinctly remember them saying, never concede anything. That's just terrible advice, just really terrible mistake. If you have to concede, make the concession, then move on to why that weakness isn't all that important for your case. Now, when you go into oral argument, you have to be prepared to talk. You have to have a little things you're going to say, even if the bench has no questions for you at all. It's always a mistake to try and repeat everything you have in your briefs because you're not going to be able to get through it. I think it's best to usually have 3 or 4 or maybe 5 points you want to hit. Highlights you want to hit, most important points you want to hit, the most weak points of your opponent's case you want to hit, just a very small handful of things you want to hit on. But the most important thing to do is listen very carefully to the questions the judges ask you and answer them to the best of your ability, because that's how you find out what we're thinking about, what bothers you, bothers us about your case. It's the one chance you have to find out what we're thinking before you get the decision. And when you get the decision, it's too late to try and influence our decision. So don't get stuck on getting through your outline, covering all the points you want to make. Take those questions, answer them carefully, accurately, honestly, without being evasive. That's the most important thing you can do. It's very important to prepare this in advance. If you have the luxury of being able to do kind of a full moot court session with some colleagues, that's wonderful. A lot of appeals don't warrant that. A lot of times you just can't afford it or can't find the people who are willing to spend that time helping you prepare. That's okay. I spend a lot of time, even now that I'm a judge, pacing up and down my office, talking to myself. Sometimes I'm talking about cases. Sometimes I'm just rambling on to myself about some other thing that's bothering me. But practice out loud. Say what you're going to say. Listen to yourself. See how it works. Try it a different way. See and make it better. The more you do that, the more your answers will improve, and also the more comfortable you'll get. You'll be less nervous when you're standing in front of real people talking after you spend some time practicing, even if it's by yourself in your office or your home or wherever. So Caroline, anything to add about oral argument?
Not a whole lot. I'll just say that, yes, prepare. But one thing that I found helpful was use your opposing counsel's brief as a guideline, as an outline for questions that you might be asked, even if you think they're frivolous, because sometimes that happens. Have at least a response to anything that the other side has raised, because typically that's where some of the questions come from, but sometimes the judges have thought of questions on their own. And one other great thing about appearing before the BAP is I got to see all the calendar matters before me. I think I was one of the last ones last year when I did oral argument. So you get to see the kinds of questions that the judges are asking. And the Judge Faris and the other BAP judges would never be this way, but I was involved in an appeal that actually we lost at the BAP, and we also lost at the trial court. But at the Ninth Circuit, the other opposing counsel, before he even uttered the last syllable of his name when he was making his appearance, one of the judges jumped in and asked a question, and it was very pointed. It was like, don't you think that your client has gotten enough money out of this case? It was something like that. So you got to be prepared for somewhat aggressive questions. And like I said, I've never seen Judge Faris or the other BAP judges jump in on with a question like that. Although I will say, having sat there, you can kind of tell where they're heading with some of their questions. But yeah, I mean, all you can do is prepare, and that's the best that you can do. You can't anticipate every single question that might come your way. You can't anticipate how the panel is going to feel about your side of the argument. But again, you start with your brief. and start with the other side's brief and have your comments ready. And that's probably it. I like the point about conceding if necessary. I've had to do that. I've definitely had to do that many times, not just on appeals, but with the court. And I think that that builds integrity with the court. I mean, you're not just going to say, oh, no, Your Honor, that's not a problem at all. If you realize that this is a weakness, then I think that it builds credibility with the court as well. So I really like that point. And that's kind of it for me on oral argument. I am in court every single week. We typically are doing Zoom here in the Central District of California, but I've gotten more and more comfortable with it. And I love the idea of practicing, rehearsing. I've done that. I've made my colleagues sit there and fire off a bunch of questions and all that. So it's very fun. I think it's fun preparing for oral argument.
Yeah, sometimes the questions are kind of left field. I remember one of the last things I did in practice was I argued a case in the Ninth Circuit, and my case was towards the end of the calendar. So I sat there like you did, Caroline, and watched some other cases go. And one of the earlier cases on the calendar was a criminal case coming out of Guam, actually, where the guy had been searched at the airport and they found, I think it was drugs or something like that. And it had been a border search. And one of the Ninth Circuit judges said, well, this fellow flew from Hawaii to Guam. Why is there a border search at Guam? Isn't it all part of the USA? And I remember the lawyer kind of stood there and he actually looked over at his opposing counsel and they both kind of looked at each other with puzzled looks on their faces and say, I don't know. We've flown back and forth. We always get searched when we get back to Guam. I'm not sure why that's legitimate. So that's an example of a case coming out of a question coming out of left field. And he gave the honest answer. He said, I don't know. I just don't know.
Wait.
All right, well, that's all we have for the planned presentation. We've got a few minutes left for questions. Be happy to answer any questions you've got. I think I have just about everybody muted, but you can unmute yourself and speak up, or you can use the hand raise function or whatever you want to do. So please go ahead.
Hi, Judge Faris and Ms. Djang. I just have some questions, if that's okay.
Sure.
And first, I want to note that something very exciting in one of my cases happened. We filed a stay application in the Boy Scouts bankruptcy with the U.S. Supreme Court. And just earlier today, Third Circuit Justice Alito made a call for response. And so.
Wow, great. That's excellent.
Very exciting.
And so I just, first question is regarding statutory mootness. I'm just curious, the 363M, whether there's a sale of estate property outside of a plan of reorganization, does an objector have to object to the buyer's good faith purchaser status prior to appeal, or is that a requirement, or is it okay to raise that later when the 363M issue actually kicks in?
I think you have to raise it at the trial court, because if the trustee is going to be asking for that finding, I think you have to explain to the district judge why the evidence doesn't support that finding.
I agree. And I want to say, again, having worked at all full service law firms, one thing that I've heard from non-bankruptcy attorneys is a 363M order is better than title insurance because it's unappealable. It's, the property is yours. You got it in good faith. You paid the highest and best price for it. I mean, that order is like gold. So all of that has to happen at the trial court level.
Also, when it comes to material and adverse modifications to a plan of reorganization, under the bankruptcy code, they don't require, the code doesn't require that bankruptcy courts give notice to creditors, of any, request by the debtor to approve the modification to the plan. And so my question is, they only require that they give notice and hold a hearing, and they give notice first to the trustee, the U.S. trustee, I believe, and then the official committee of unsecured creditors. So my question is, if that's not required, there's no code notice required to creditors, does that mean that appeals of those material and adverse modifications to a plan after the vote has already happened, does that mean that that you're out of luck if the debtor brought it up in a hearing to say, hey, let's amend court, please amend this plan, but there was no disclosure statement that was ever given and approved by the bankruptcy court of that material and adverse modification prior to them asking the bankruptcy court to approve that modification. You see what I'm trying to say?
Yeah, I think so. I mean, I think I don't know the precise answer to that question. That's kind of beyond my current knowledge. I mean, my sense is, my gut feeling is that if you don't get notice of something, then you can't be criticized for not objecting to it. It's just logically, that's the way it seems to me it ought to work. On the other hand, if you don't get notice of something, perhaps that's because the court thought it didn't adversely affect your client. But still, if you think it does, then you ought to be able to seek some kind of remedy for that. But again, that's just me thinking off the top of my head here.
Yeah, I agree, Your Honor. And I would say, even if the FRBP don't require notice to all creditors, I think the judges out here would, because I'm just thinking of some recent examples where there were material modifications to a plan and the judge said, well, you got to resolicit, you got to renotice and resolicit. And whether that was backed by the rules or not, I think the judges out here are cognizant of due process, and you can't completely change distributions to classes of creditors without them getting notice. So yeah.
I think, Caroline, I think Delia is concerned about the Boy Scouts case, I'm guessing, and that's a Delaware case, and the bankruptcy code doesn't apply in Delaware, sort of. I'm kidding about that. Anybody else? Those are good questions. Thank you for that, Delia.
I have one more question. So
Great.
I'm sorry, you were all talking about the BAP and oral argument and pithy briefs before the BAP. But if we're appealing, if we're before the Circuit Court of Appeals, who are not experts at bankruptcy, like you, Judge Faris, I mean, I guess you would advise that maybe it's okay to be a little bit lengthier and to just discuss some of the basic concepts.
Yeah, I think that's right. I mean, if you're in front of the BAP, you've got 3 bankruptcy judges, and we know all the basics. If you're in front of a generalist judge, a district judge, or a court of appeals judge, it probably does help to step back and set the stage a little bit and lay out some of the essentials. But you don't have to take a lot of time to do that, a lot of space to do that, because they've got these great law clerks who are probably going to do a lot of research themselves. So you do, I think, want to kind of set the groundwork and maybe explain a little bit why the rule is what the rule is. But still, it's still very important to keep it as brief as you possibly can.
Thank you.
You're very welcome. Anybody else have any questions? Okay, well, we're almost back to the top of the next hour. So I want to thank Caroline Djang for participating. I really want to thank the judges for giving us a chance to speak to you, and I appreciate all your attention today. So thanks very much.
Thank you.
Chief Judge Faris and Caroline Djang. It's really nice to have both of you, and also Judge Collins, who I know is here watching. Thank you very much for putting us all together. And we have our next session. Judge Collins, you want to talk about that real quickly before we recess?
So our next session will be the last of our 3. It's at the very same time next week. For those on mainland time, that'll be on the holiday on Monday. But it is now going to be basically bankruptcy basics for commercial practice. And we have Caroline revisiting us, and she's going to be paired with Chuck Choi from Hawaii and Curtis Djang from the U.S. Trustee's Office. So I hope you all attend. Look forward to seeing you on screen at that time.
All
All right.
right. Okay. Thank you, Judge. And you guys take care and have a great weekend. And we'll see you all next week.
Thank you.
Okay, thank you very much. So long.
Bye-bye.